On January 27, 2023 at 8:30 in the morning, the Winter Park Police is asking the judge in the circuit court of the 9th Judicial Circuit in and for Orange County, Florida, for an order granting temporary ex parte, which is legally defined as, it's a Latin meaning for one party, referring to motions, hearings, or orders granted on the request of and for the benefit of one party only. This is an exception for which is legally defined as something that is expected or excluded, for which is defined as to prevent or restrict the entrance of the basic rule of court procedure, that both parties must be present at any argument before a judge, and to the otherwise rule that an attorney may not notify, for which is defined as to give formal notice to a judge without previously notifying, for which is defined as to give notice of or report the occurrence of to the opposition, for which is defined as a configuration, for which is defined as relative arrangement of parts or elements in which one celestial, for which is defined as related to or suggesting heaven or divinity's bodies, is opposite another in the civil and criminal courthouses and similar in Orange counties in the state of Florida, as well as in the federal courthouse in the Middle District of Florida, such as the sun or in the sky, or in which the elongation, for which is defined as the angular distance in the sky between celestial bodies and another, provided profound, which it revolves in or between a celestial body and a particular point, such as the point where its path intersects the horizon. Right now, that's ex parte, right? So now, but I asked the state of Florida, right, on this August 12th, so I got to get down to which one, okay, because it's like 3 different times that I asked the state of Florida for this same protection. Well, but it's for domestic violence. So what I'm going to do is I'm going to read my motion, because they may not let me say this in court, because they never let me talk before. But see, what I'm trying to show my people is, in court, everybody know what everybody gonna say because of discovery. So like yesterday on January 20th, I went and put my defenses in so the judge will know, and Winter Park Police Department's attorney will know what I'm gonna say. So now on August 4th in 2008, in the county court in and for Seminole County, Florida, with case number 2008 MM0072218, the state of Florida versus Tommy Castle. It says notice for pretrial conference set for 8/21/2008 at 9 a.m. in courtroom 4C at the Criminal Justice Building, 101 Bush Boulevard, Sanford, Florida, 32773, before Judge John Woodard III. This is a motion by defendant Tommy Chancey Castle from the Florida Rules of Court, Rules 3.150, 3.152, 3.153, 3.191, 3.200, and 3.220 of the Criminal Procedure Rules of Preliminary Proceedings. A. Rule 3.10, Journal of Defendants. Offenses. It's A, Rule 3.150, Journal of Offenses. And then it's me saying, 1, defendant Tommy Chancey Castle enters a plea of not guilty to the state of Florida's own breaking of around about 23 out of a possible 26 of my constitutional rights, and around 8 out of a possible 10 of my Bill of Rights given to all citizens of the United States of America. Then B, joiner of defendants. 1, the state of Florida, Officer Covers KOMIVES, Officers ID 219, Lake Mary Police Department, and all defendants involved in the cases in the civil courthouse in Seminole, in and for Seminole County, with case number 07 CA 3119-16L and 08 CA 1618, excuse me. Man, I better put that right there. 09K in the Circuit Court of the 19th Judicial Circuit in and for Orange County, Florida, with case number 08CA 3687-39, is charged with accountability for each offense charged. Now, that's me saying, see, in that same courthouse in August 4th, 2008, I had said that I was also being in a conspiracy in Orange County. That's why this hearing on January 27th in 2023 is a crime, because I've already asked this court, right? I already asked the state of Florida for the same protections that Winter Park is now asking for me. Now here it is, 2. Each defendant is charged with conspiracy. Now this is me on August 4th, 2008, telling the state of Florida that they were charged with conspiracy, domestic violence, and repeat violence. And with these charges, Tommy Chancey Castle respectfully, see, I respectfully asked the court on behalf of Tommy Chancey Castle, Benita E. Castle, and Folk Houses Incorporated for an injunction. See, I asked for an injunction for protection against domestic violence filed under Section 741-30 Florida statutes, and repeat violence under Statute 784-046 of the Florida statutes. And this has been asked for repeatedly in the circuit court in and for Seminole County. These offenses alleged to have been committed in furtherance of the conspiracy. Defendant Tommy Chancey Castle and this court asked this court for the legal term concourse, which is spelled CONCOURSE, which is when a civil matter becomes criminal. And this has now happened with these charges being filed against me by the state of Florida. See, this is the state of Florida charging me in 2008, just like the state of Florida through Winter Park is charging me on January 27th in 2023. Now, I charged the state of Florida, whether y'all think it's crazy or I was crazy or whatever you thought. But boy, if I didn't do this in 2008, what chance would I have January 27th? What in 2023? If I didn't protect myself in writing on August 4th in 2008, man, I'd be through now. I wouldn't have no evidence in support of my mental capacity. They trying to act like I'm crazy. See what I'm saying? Now, 3, conspiracy is charged on all defendants, and it is alleged that the offenses charged were part of a common scheme or plan. Rule 3.152, servants of offenses and defendants. Service of offenses. 1. In this case, with case number 2008 MM 0072221A, and the second offense, 2 offenses are improperly charged in the indictment, and defendant Tommy Chancey Castle has a right to a severance of the charges in this severance of the charges in this motion. 2. In this case, with case number 2008 MM 0072221A, 2 or more charges of related offenses are joined in a single indictment. See, now this me back when I was 39. I just turned 54. And they trying to say that I'm incompetent. But man, look what I wrote. See, this me teaching myself the law. Court nevertheless shall grant a servance of charges on defendant Tommy Chancey Castle Sr.'s motion. See, this a motion. The motion comes from defendant Tommy Chancey Castle before trial on the evidence contained in the respective cases that are given as discovery. See, I'm giving this as discovery. This back in 2008. So I had to give it as a discovery again, so they won't put me in a mental hospital. See, that's how they do, man. They can't beat you, so they defame you. See, they start talking about you crazy. See, that's the only way they can beat you. See, because now they got to go to court with this evidence. And if they was to be around anybody competent, anybody, they'll see that this man asked for the protection from you. Now you asking for the protection from him 15 years after he asked for protection from you? Come on, man, that don't make no sense. See what I'm saying? So, okay, and it says, okay, a motion, Tommy, severance of defendants, B, right? It's on 1. On motion by defendant, Tommy Chancellor Counsel Sr. asked this court in order of a servants of defendants and separate trials. A, this motion comes before trial and is necessary to protect the defendant, Tommy Chancellor Counsel Sr.'s right to a speedy trial and is appropriate to promote a fair demonstration of the defendant, Tommy Chancellor Counsel's guilt or innocence. Rule 3.153, timelessness of defendant's motions. A, defendant Tommy Chancellor Counsel Sr. with this motion has made it in a timely manner for severance, and it has been done before trial pursuant to per Rule 3.153. Rule 3.119, speedy trial. B, speedy trial upon demand is demanded by defendant Tommy Chancellor Counsel Sr., whom has been charged with a crime by indictment, shall have the right to demand a trial within 60 days. By filing this motion, defendant Tommy Chancellor Counsel asked this court for a demand for speedy trial due to my constitutional rights being violated by the... See, now this means, man, I was 39 years old and now these people at 54 trying to say I'm incompetent. And I'm saying, well, how can you say that at 54? State of Florida and all defendants involved in this case. Rule 3.200, notice of alibi. Defendant Tommy Chancellor Counsel would like to enter into evidence a written alibi to these charges. The alibi is contained in the court discovery for which I informed the courts of the financial hardship and emotional stress that the defendant in this case with case number 07CA3119-16L has caused myself and my family, and by Judge Clayton D. Simmons and by Judges Clayton D. Simmons and John D. Galuzzo's violation of Code of Judicial Conduct, Canons 1A, judge should uphold the integrity and independence of the judiciary. Canons 2, a judge shall avoid impropriety and appearance of impropriety in all of the judge's activities. Canons 3, a judge shall perform the duties of the judiciary office impartially and diligently. Canon 4, a judge is encouraged to engage in activities to improve the law, the legal system, and the administration of justice, and due to the misconduct of the state of Florida judges, the defendant Tommy Chancellor Counsel has been charged with a crime. See, well, okay, it's getting long, so I'm gonna stop it right there.